Shannon, the travel ban decision, what do we know there?
It is a 5-4 decision authored by the Chief Justice John Roberts. He says the proclamation, that's Travel Ban 3.0, is squarely within the scope of presidential authority under the INA. That's the immigration law. He says there is no contention. The plaintiffs cannot say that they have been, their rights have been violated, that the proclamation violated the statute. Essentially, he's saying here that the president acted within his authority, within his scope, when he drafted the travel ban. They also note that there are a number of majority Muslim countries that have gotten themselves off the list because they have complied with what came as part of Travel Ban 3.0, which was, listen, if your country will give us the relevant information we need, they'll properly vet people, and they'll actually get that information together before we allow those people into this country, we'll take them off the list. So Iraq is off the list, Sudan and Chad are off the list. He said there are all kinds of things built in here that make this a fair and legal way to handle this. He says also the proclamation creates a waiver program open to all covered foreign nationals seeking entry as immigrants or non-immigrants. He says based on all of these different things that are part of the proclamation, the government has set forth a sufficient national security justification to survive a rational basis review. So what happens now essentially is they're reversing and remanding the case. They're sending it back down to the lower court with these instructions that this is the way they should consider the case. But essentially what it's saying is that the president is completely within his authority, within the framework of immigration laws as they exist now, to do what he did in Travel Ban 3.0. It is a split that you would expect. There are some concurrences and additional things, but it's Chief Justice John Roberts writing this, joined by Kennedy, Thomas, Alito, and Gorsuch. Breyer wrote the dissenting opinion. He's joined by Kagan, Sotomayor, and Ginsburg. So not a surprising split there. But I have to say, during the arguments, there was a lot of talk about whether or not the president's statements during the campaign and when he first became president about a, quote, so-called Muslim ban or locking down the borders, whether those things should be allowed in or not, or whether you should just look to the text of the law. Now, it sounds like what the majority's done here, and it's a long opinion, I haven't read all of it, but skimming it, it looks like what they did was stick to the text of the proclamation itself and not delve into those other comments. The lower courts who had ruled against earlier versions and this version of the travel ban had found that the president's statements and those of many of his staffers, they referenced Rudy Giuliani and others, saying that people who had been supporters of his, surrogates of his, had made similar comments, and those lower courts viewed all of those comments as a whole in striking down the travel ban. It looks like here by 5-4 in an opinion authored by the Chief Justice, they've looked to the text of the proclamation and have said the president did not go beyond his powers. So at first reading, it looks like it's a big win for the administration on Travel Ban 3.0, but it looks like, again, further court action is going to take place now because this is sent back down to the lower court, but with strong guidance and very strong statements from the Supreme Court.